I do not believe that we have a government that acts consistently in the national interest. And I do not think that we have a properly functioning democracy.
I'm pleased to rise for the third time to propose Bill C-208 to the House of Commons regarding the fact that justices of the Supreme Court should be bilingual. Today, my New Democrat colleagues and I are coming back with my bill C-208 that seeks to make French-English bilingualism a new condition for the appointment of justices of the Supreme Court of Canada. It's high time that we make the understanding of both official languages an essential condition for the appointment of justices of the Supreme Court. Access to justice. Let me talk to you about why this bill is important. This is a question of access to justice. The Supreme Court is the highest court in the land. It's very important that judges can understand both official languages without the help of an interpreter. I have a great deal of respect for the work of interpreters, but we do know that interpretation has its limits. Many lawyers have noted errors or omissions during the interpretation of their pleas before the Supreme Court. There are many examples of dubious interpretation at the Supreme Court. A lawyer pleading before the Supreme Court mentioned a certain Mr. 5 heures. This was translated by the interpreter as Mr. 5 o'clock. Even the Official Languages Commissioner, Graham Fraser, stated that it was necessary to understand arguments without an intermediary. In June 2009, he told the Justice Committee members, quote, "Given the complexity and exceptional importance of cases heard by this court, a judge should be able to hear arguments that are presented without an intermediary in order to properly understand the legal arguments that are very nuanced and complex," unquote. The presence of unilingual judges at the Supreme Court also poses a problem during in-camera deliberations that are therefore without an interpreter. Francophone judges always have to communicate their opinions, their ideas, and their knowledge in their second language. There is a risk that they will be much less precise. If the justices have a functional mastery of both official languages, everyone could use the language of their choice. The bilingualism of justices is therefore a matter of equality between Francophones and Anglophones in access to justice, Mr. Speaker. Secondly, the bilingualism of Supreme Court judges ensures the equality of both official languages.
That the Supreme Court has recognized the equality of French and English.
Legislation is drafted in both official languages and both versions are equal. Neither has precedence over the other.
Duality is part of our Canadian identity. We have to embrace it.
Are we talking about real equality when a Francophone appears before the Supreme Court, the highest court in the land? It doesn't exist to reward ambitious judges and lawyers. It exists to render justice to all Canadians.
Serving as the Supreme Court is not a right, but having a fair justice, access to the justice, is a right. Remember that the court is there to serve the Canadian, not the interests of the judge. L'enjeu du bilinguisme.
The issue of bilingualism of Supreme Court justices has been debated for many years now. It's the highest court in the land. But people can only be heard through the filter of interpretation? I say no. If we want true equality between both languages in this country, it's important that bilingualism be an essential condition for the appointment of judges to the Supreme Court.
The Supreme Court of Canada is a model of institutional bilingualism, which is in compliance with Parliament's will to have national bilingual institutions. Mr. Speaker, Our government will keep its commitment to preserve the equality and neutrality under the law. In order to do so, we propose to continue to be guided by the principles of merit and legal excellence in the selection and appointment process for judges to the superior courts of the provinces, federal courts, and the Supreme Court. Mr. Speaker, our government has appointed 400 judges to date to sit in various courts of justice in this country. We're proud of having appointed them and these highly qualified lawyers. These appointments incarnate the principles of merit and legal excellence that continue to inspire our decisions as far as appointment of judges are concerned. Merit and legal excellence are the basis of the appointment process for judges. The other criteria are knowledge of the law, judgment, work habits, ability to write and communicate, honesty, integrity, concern for fairness, and a social conscience. Bilingualism also figures among the factors to take into consideration. The government, therefore, takes into account language skills of the candidates and ensures that it offers access to justice in both official languages. We are determined to create a federal legal system that has equal access to justice in both official languages. In order to ensure there's a broad pool of candidates that is balanced and equally balanced with bilingual candidates, the government continues to invite lawyers associations and people from Francophone communities to identify and encourage people who have the required skills to submit their candidacy. We don't deny the importance of language skills, particularly when there is a need that has been highlighted. However, the merit remains the most important factor to take into account when the time comes to appoint judges. First and foremost, our government is determined to appoint the best qualified people. We will continue to appoint competent people who are dedicated and adhere to the principles of a gender-balanced court, cultural diversity, and bilingualism. Mr. Speaker, the Supreme Court of Canada plays a fundamental and crucial role in our democratic society, in particular as the ultimate guardian of the values enshrined in our Constitution. As a result, it is important that judges be able to choose the most distinguished jurists and the most competent in the country. That is why we take great care to choose the best candidates as a result of their knowledge and experience, social conscience, and in order to fill the positions available in the court. Justices appointed to the Supreme Court, justices rather appointed since for the last 130 years, have been the best the court could have asked for. They have a remarkable intellectual capacity, a superior aptitude for drafting judgments, innovative thinking in terms of new legal issues, and a great sensitivity to in terms of the diverse values enshrined in the Constitution. All of these qualities are part of the concept of regional representation. It's important that the Supreme Court represent all Canadians. This is the reason why we take this factor into consideration. A strong majority of the current judges sitting on the Supreme Court have a mastery of both official languages and are perfectly capable of hearing a case in either language without the help of simultaneous interpretation. The judges of this court also have the possibility of taking language training. Furthermore, they are encouraged to do so. The translation and interpretation services are of a very high quality for hearings before the court. Equally, all judges of the court receive the support of at least one bilingual law clerk. Mr. Speaker, the current requirements of the Supreme Court Act as far as the composition of the court are concerned, as well as the historic use and regional representation, allows us to keep a firm commitment to bijuralism. The actual requirements have shown that we give this great importance to these appointments. However, this factor must not prevail on the merit and excellence of judges from a legal perspective. And it's for all of the above-mentioned reasons that we cannot support Bill C-208 in its actual form. Thank you, Mr. Speaker.
I will support this bill going to second reading, albeit with some minor cautions and concern to which I will return in a moment. I believe as well that my colleague from Saint-Laurent-Cartierville is in support of this effort, which to me reinforces that this bill is worthy of review and support at second reading.
Ideally, these types of changes should be driven by government acting in a coordinated manner and in the national interest. The honourable member from Acadie-Bathurst would surely agree with me that the constant tinkering with the criminal code, as an example, for purely partisan reasons, is not the ideal. I have similar concerns with respect to the Supreme Court of Canada Act. We should not, in normal circumstances, change such an important piece of legislation by means of a private member's bill. And again, I say this knowing that one of my former colleagues, now the Mayor of Montreal, was one of the first to suggest changes to the Supreme Court of Canada Act that are now before the House. We do not, however, operate in normal circumstances. Canadians also expect that matters related to the Supreme Court be treated in a non-political way, and we expect appointments to be made to ensure a proper linguistic, gender, and regional balance as part of the process. Again, these are not normal times. We are reminded of the actions of the current Minister of Justice who botched the appointment of Justice Nadon, an individual who was well respected and a capable jurist, someone who served on the federal court with honour. Justice Nadon endured public scrutiny and no doubt unwelcome attention simply because the current government mishandled the Supreme Court process. The issues around French language and linguistic duality are important and meaningful. Let me close by again complimenting the member from Acadie-Bathurst for his effort